Tonight, abortion access is where we're starting. In Kentucky, it's still in limbo, even though Kentuckians voted on an amendment about the procedure during the November election. Let's take a moment now to reflect on recent events. Last summer, the Supreme Court overturned Roe v. Wade, leaving the decision to individual states. Here in Kentucky, trigger laws went into effect, which practically created a total abortion ban in the Commonwealth. However, the laws have been in a back and forth battle in court ever since. Then, during the November election, Kentuckians voted no on House Bill 2, which would have added anti-abortion language to the state's constitution. The thought was that the Kentucky Supreme Court would make a decision about abortion by the end of last year, but that didn't happen. And now there are new members sitting on the court. So what does that mean for Kentucky? LEX 18's political reporter Carolina Buchek goes in depth on the debate.
Protect Kentucky Access!
2 months after voters defeated Amendment number 2, abortion in Kentucky is still banned for the most part. And the reason for that comes down to the Kentucky Supreme Court. This court has not yet decided on whether to keep or suspend 2 of Kentucky's major abortion bans.
This court is now in session.
The case was taken up by the court in November, exactly 1 week after voters rejected putting anti-abortion language into the state's constitution. And since then, Kentucky has been waiting for a decision. But that decision won't come from the same court that heard the actual arguments. Because 2 new justices have been seated this year and a new chief justice has been selected. So what happens now? Well, the court's spokesperson tells LEX 18 that, quote, the change in the composition of the Supreme Court does not impact its ability to rule on pending matters, including cases heard by the previous court. She goes on to say that the new justices can request additional arguments to be scheduled. However, they have access to case briefs and recordings of the initial oral arguments. So the new Kentucky Supreme Court can make a decision at any point. And what exactly are they considering? Well, they're actually only deciding on whether or not Kentucky's abortion bans should be blocked as the legal fight over them continues. It's a temporary thing, but it'll have a major impact on abortion access. And the lawyer for Kentucky's abortion providers told the court that access needs to be reinstated. She argues that abortion was allowed when the Constitution was created.
So even at that time, it was well understood and established that common law, before we have the statutes we have now, allowed abortion at least to some point into the second trimester.
But the Attorney General's office told the court that the Constitution does not protect abortion access, so the bans should stay.
There's nothing in our history, nothing in our traditions in Kentucky that would suggest that that broad, expansive right exists in our Constitution.
So when can we expect the decision? Well, the next date for the court to issue fresh opinions is January 19th, less than a week from today. But there's no telling if the court will have a decision by then. In Frankfort, Carolina Buchek, Evening Edition.